The first thing is to consider is, what do we mean by ownership? There are two main ways in which property can be owned: beneficially or legally. A trustee of the property owns the property legally. That means it's in the trustee's name, so their name's on the title deeds. It means that they can sign the conveyancing paperwork when the property is sold. Beneficial ownership, on the other hand, means that you're entitled to a share of the sale proceeds once it is sold. Often, trustees or legal owners and beneficial owners are the same people. For instance, if two people in a relationship buy a property together, it's very likely that they'll be both the trustees or the legal owners and the beneficial owners, because they're holding it on trust for each other. And when it's sold, the beneficial interest or the sale proceeds will go to them. But legal ownership and beneficial ownership can be separated. So for example, someone could own a property in their legal name, so be a trustee, but hold it for someone else. So that could be for someone who's underage, for instance. It could just be for another member of the family, or it could be for someone unconnected with them. If you are a trustee of a property, that means that you owe certain duties to the beneficial owners. You have to make sure that you're preserving the value of the property, for instance. It means that you shouldn't sell it at an undervalue, because that will mean that the beneficial owners aren't getting as much out of the sale proceeds as they should. So there are all sorts of duties that a trustee is bound by and should be taken into account.